Hello and welcome. I am Justin Landry, host of today's conversation, and today we are joined by two extraordinary Canadians. Joining me today is Ernest J. Weinrib, or Ernie to his friends. He graduated from the University of Toronto in 1965 and received his PhD in classics from Harvard University in 1968 and his JD from the University of Toronto in 1972. He's a university professor and Cecil A. Wright Professor of Law. Professor Weinrib has taught at the University of Toronto in the Department of Classics since 1968 and in the Faculty of Law since 1972. In 1984, he was visiting professor of law at Yale Law School. He has also been a frequent visitor at the Advanced Legal Studies Center at Tel Aviv University. And from 2014 to 2017, he was Sackler Professor by special appointment at Tel Aviv University. Professor Weinrib's teaching and scholarship have concentrated on tort law and the law of restitution and legal theory, and he is recognized internationally as a leading figure in the theory of private law. Among his books are The Idea of Private Law, Harvard University Press, 1995, Oxford University Press, 2012, and Corrective Justice, Oxford University Press, 2012. He is a fellow of the Royal Society of Canada and a foreign honorary member of the American Academy of Arts and Sciences. In 2014, he gave the Clarendon Lectures in Law at Oxford University on the jurisprudence of corrective justice, and he's here with us today. Professor Weinrib, thank you very much for joining us.
It's a pleasure.
Joining Professor Weinrib is Distinguished Jurist-in-Residence, the Honorable Mr. Justice Robert J. Sharpe, or Bob as his friends call him. Robert Sharpe was a judge of the Court of Appeal for Ontario from 1999 to 2020 and is currently Distinguished Jurist-in-Residence at the Faculty of Law. He did graduate with a BA from the University of Western Ontario in 1966, a Bachelor of Laws from the University of Toronto in 1970, and a Doctor of Philosophy degree from Oxford University in 1974. He was called to the Bar of Ontario in 1974 and practiced in the area of civil litigation. He was a professor at the Faculty of Law, University of Toronto from 1976 to 1988 and served under Chief Justice Brian Dickson as Executive Legal Officer at the Supreme Court of Canada from 1988 to 1990. Robert Sharpe was appointed Dean of the Faculty of Law, University of Toronto in 1990 and served in that capacity until his appointment as member of the Ontario Court of Justice, General Division, now Ontario Superior Court of Justice, and that was 1995. He was elected a Fellow of the Royal Society of Canada in 1991 and as an Officer of the Order of Canada in 2023. Robert Sharpe has written several books on law and Canadian legal history, including Good Judgment, Making Judicial Decisions, 2018, and he does have a new book coming out this fall, which maybe we'll talk about later, and we're delighted to have him joining us today. Justice Sharpe, welcome.
Thank you very much.
How about those introductions? Very accomplished Canadians. I wasn't making it up. There's some things that I think were left out. Ernie, I know your love of woodworking and you're accomplished in that, but we'll. I'm joking. I just wanted to see.
I was wondering where that came from. Yes.
But you're both so accomplished. And there was a conference at the law school recently, and in that conference, professors were delivering papers on faculty, and it struck me how loved you both were. And in our 75th anniversary, celebrating modern legal education, we wanted to take the opportunity to talk to you both, talk about your backgrounds, what perhaps got you interested in the law, why U of T law, what you were feeling at the time, and so on. So I'll start with you, Ernie. Your family background, where were you raised? Where do you come from?
So I was born in Toronto, and I've lived most of my life in Toronto. Aside from the years in which I did graduate work in classics at Harvard, those 3 years, and aside from visiting academic appointments elsewhere, I've just been a Toronto guy for my whole life.
And when you were younger, did you was it something that you wanted to do, law? Did you think about being a lawyer from a young age, or when did you
No,
decide?
no, no. So my path is a little bit um, unusual, I guess, in that respect. I had never intended to do law. The um, I had I got an undergraduate degree at the University of Toronto in classics, as you mentioned in your introduction, and then I went off to Harvard to do a doctorate in classics with a specialization in Roman history, and um, and I thought my career was and my future was pretty well set, that I would do this doctorate at Harvard and then return to Toronto to teach classics and spend the rest of my life teaching Latin, Greek, and Roman history. Um, now, so I had never intended to do law. That had not been something that I even remotely considered. And uh, but while I was doing classics, doing classical history, doing Roman history, I got quite interested in the relationship between Roman politics and Roman law. And I actually did some work on that at Harvard. I was taught Roman law at Harvard by a person who was who was or certainly became very distinguished in the academic legal world, Charles Fried, who later wrote a classic book on the theory of contract law, and then later in his life served as Solicitor General for the United States. So I'd gotten interested in law in that way, but I was interested in Roman law, and then came back to the University of Toronto, as had been my uh, plan, to teach classics and teach Roman history and do research in Roman history, which I was doing. And I was, as I say, especially interested in this connection between Roman politics and Roman law. But I realized as I was doing that work that there was actually something that I was missing, that there was something about the way lawyers thought that I wasn't capturing, because I had never been trained in it. And so I decided, while teaching classics, to spend a year studying law at the law school. So I was teaching classics at University College and on the other side of Hoskin. And so I applied to law school, intending to be in law school for 1 year and develop some sort of feel for how legal systems work, and then go back to teaching Roman history. Um, and so what I did is I took that year, as I say, not intending a legal career at all. That I, I knew that was, if I actually did the degree, that might be a possibility, but that wasn't my intention. And after finishing the first year, I actually um, had enjoyed that year thoroughly, and had done well at law school. I had stood first in the class that first year, and I thought to myself, well, I may as well do the other 2 years and at least complete the degree, and then go back and teach classics. That there wasn't any hurry to go back and return to my position in the classics department. Um, and so that's what I did. Um, and then when I was in third year as a student, um, the dean of the law school at the time, Ronnie McDonald, sort of called me into his office and said, so I was, as I say, in third year as a student, called me into his office and said, would you consider teaching law, joining the faculty? I was astonished that that was even a possibility. And I said to him, yes, I would consider teaching law. I would be happy to do that, but I have to maintain the connection with the Department of Classics. So I have to continue teaching in the Department of Classics. So if you can arrange that, that would be fine. And so that's how I found myself, um, rather unexpectedly, as a professor of law, directly out of law school. It was so unusual that the people that I was teaching in my first year um, had been classmates of mine
Right.
when I was in my third year, because it was the second and third year then, as now we're taking the same courses. So I was their classmate from the year before, and here I was uh, uh, teaching law, and I was still continuing at the Department of Classics. So, and I had this feeling all the way through my the oddity of it, even as I had been a law student, that when I was north of Hoskin Avenue, I was a law student, and when I was south of Hoskin Avenue, I was a professor of classics. So I came to law in a completely unintended uh, way. It had never been my intention to actually uh, do law in any real sense. And I never did do law. I never practiced law. Uh, uh, Here I ended up spending the bulk of my time working with legal material. So not a typical path. And it's certainly not been an ambition of mine or even an intention of mine. It was quite accidental.
I was going to say the future law students who might be watching this, or even the students we have now, they might be fascinated by the approach and the pathway that you took. It's not the same for everyone, right? And I'm interested to learn about the dynamic too in the classroom of teaching your former classmates. But we'll ask Robert the same question. Where are you from, Robert?
I grew up in Picton, Ontario, small
Okay.
town. So I had a very small town upbringing. Went to the local high school where I had some surprisingly good teachers. And then from Picton, I went to Western, where I studied political science and history. I didn't really have any clear idea of what I was going to do. I think when I was at Western, I thought maybe I'd do a graduate degree in political science. But really, I lived in a residence where there were a lot of law students, and I used to have dinner with them. And just listening to them talk, I thought, you know what, that kind of sounds interesting. And maybe I should give that a try. So it wasn't a deliberate, it was almost a happenstance decision that I decided to go to law school. And first came to Toronto when I started first year here in 1966.
Okay.
Yeah.
Now I'm interested in your parents. Like, so this was kind of a new idea for you, Bob, that you would so your parents weren't lawyers and
No,
your
my parents were not university educated. They were very keen on education, very keen that I have one brother that we both would go to university, but they were certainly not lawyers or university educated people, and they just wanted their children to have the advantages of a university education. I really don't think I met a lawyer until I was at Western. I had no legal connections in my family whatsoever, so it was a whole new adventure. And I guess because I was very interested in political science and history, it was a kind of a natural transition, if you like, to law. But it really came after I was at Western.
Okay. And Ernie, same with you. Were your parents academics or?
Oh no, not at all. Uh, um, my parents had a shop in Toronto on actually not far from the law school on St. Clair, um, and they um, they were very surprised when I decided to go to law school. They didn't see the point of that. Of course, my brother Arnold, who is a few years older than I, had gone to law school. So they were aware that there was something called the law school, and that it was a means of professional advancement. But they were not. My father was actually a very he was not university educated. He grew up in Europe, but he was a very spectacularly self-taught person. Like, he could talk about literature or philosophy, even though this had nothing to do with his workaday life, running this shop on St. Clair Avenue. But they were, when I went to law school, and when I then made the decision to continue on to the end of the degree, my parents were very mystified by this, because they had been immigrants who had struggled, as many immigrants did and do, and they couldn't understand why, having a profession already as a university teacher, I would want to do something that might postpone my development of my professional um, future. So they were not, they couldn't understand why I would want to do this. An even more remarkable reaction came from my father-in-law. I'd who, when I told him that I was going to spend some time at the law school, expressed his profound disappointment. And I asked him, "Why are you disappointed by going to law school?" And he said, "Because I've never known a dishonest classicist." Um, uh, so anyway, so that was sort of the background. So it ended up, from the family point of view, as I look back on it, it seems so bizarre now, because I and my brother and my wife landed up teaching at the University of Toronto, and we both have um, two of my three children are legally trained, and of course, one of Arnold's children is a lawyer in downtown Toronto. So it's a very strange family twist. Um, um, my son, who teaches law at Queen's, is sometimes asked about the family connection. And they ask, "Well, these other Weinribs at the University of Toronto, are they related?" And he says, "Oh yes, they're related." And then he's asked, "How do you account for the fact that you're all teaching law?" And he said, "Well, the one thing about my family that you have to know is we have a very narrow range of skills." From the standpoint of family background, it was completely unexpected that I, at least, would do law. I think with Arnold, they had different expectations. But
Well, it's fascinating, and of course, your brother is also a very well respected Canadian and law professor, and also loved by students and faculty. And I can just imagine Dean McDonald, having that meeting with you, offering you the opportunity to teach. And correct me if I'm wrong, but you met Lorraine, your wife, at law school.
no, I didn't know, the other way around, actually.
Okay.
That she was an undergraduate in classics when I knew her, an undergraduate in classics at York. So she wasn't a student of mine. I was teaching at the University of Toronto, but we had lots of overlapping friends, and we got to get, and that's how we got together.
There you go.
She had decided, she was a spectacularly good classics student at York, and she had decided to do graduate work in um, classics, in Greek literature, in the United States. And by that time, I was teaching classics, and I could see that the market was turning, and that by the time she finished her doctorate, um, there may not be jobs, or there might not be jobs in Canada, or and so I told her, I said, why don't you forget about doing graduate work in classics and instead come to law school and we'll get married. That was my proposal to her.
How could you say no?
She denies, I have to say that she denies that any such conversation ever took place. She denies that there was ever any proposal. I don't, though she can't explain how we ended up married. But in any case, she was in law school because I had talked her into it. And she was a very reluctant recruit to law school. The law school experience was not good for women in those times. It was, so this was the very early 70s. She graduated in 1973. And I I would not have been surprised if at any time she had come back home from the daily grind of classes at the law school and announced that she was leaving the law school and going to study medicine. That would not have surprised me at all, because it wasn't such a great experience. Being at the law school was not a great experience for her, I think, or for many other women, and she didn't really find her love of law till she started practicing law as a constitutional lawyer at the in the Ministry of the Attorney General for Ontario, and then she actually fell in, and then she fell in love. She had very good mentors there, and she fell in love with law. And so, but so her presence in law is also a different story. But I didn't meet her in law school. We were we got married at the end of her first term as a law student. She was a first-year law student. That was a second-year law student.
Well, she has a very good reputation too, and I'm now in my mind's eye thinking back to your time at school. And Bob, you graduated in 1970. You had quite a distinguished class. I was wondering if you could talk to us about what it was like to be in law school, and even touch on maybe who your most influential professors were, or even classmates.
Yeah, well, I loved law school, but it was very different from what it is today. First of all, it really wasn't all that difficult to get into law school. You needed decent sort of marks, but not spectacular marks the way the current class does. I did not have to write the LSAT. I think it was the next year that it was introduced, but so I have never written the LSAT, and I never will, because I'm terrified of what the result would be. The tuition was modest, and in some ways the program was modest, but I liked it. I had some excellent professors in first year. Marty Friedland taught me criminal law and became a friend and a kind of a colleague and a lifelong mentor. He later hired me when he was dean at the law school. I had Bruce Dunlop was my torts professor, a well-loved professor. Ernie's brother Arnold was in his first year of teaching and taught me, as it was then called, land law. And that was quite an experience. Arnold has a razor-sharp mind, a razor-sharp wit, and he did not, it was pretty obvious to all of us that was the case. So it was a wonderful experience. Dick Risk, really better known as a legal historian, taught me contracts, did it extremely well. So I had some very, very good people. Dean Wright was still alive. He was still the dean. He died during my first year. But so I actually heard Dean Wright give the memorable welcome to the first year class. He was a forceful, fiercely intelligent man, a very strong-willed man who had taken the law school, had left Osgoode to establish a university-based law school with Bora Laskin, and his desire to make it a great law school was palpable. He also taught us a couple of classes in this doctrine called res ipsa loquitur, the thing speaks for itself. And Dean Wright did not believe in the doctrine. And I think any student who had sat through those two classes would never dare utter the words again after listening to him demolish the doctrine. So it was a great experience, but it's a very different place, a very different place. No racialized students. There were, I think, 4 or 5 women in my class, as Ernie suggested. Even in a couple of years later, there were very few women. So it was a very male-oriented, white male-oriented place. The program was much more modest than it is today, much smaller faculty. In second year, I think we only had 1 or 2 optional courses, and it was a little more the case in third year. But law was very much taught sort of a very doctrinal approach, if I can use that word. It was much more of a black letter approach. Now, our professors were good. They were very good, and they were encouraged us to think about law deeply in terms of what were its underlying values. But there was really no overtly theoretical or interdisciplinary teaching or scholarship, for that matter, going on in the law school at that time. So I loved it. I thought I got a good education. Another feature was, when I think back, was how much we read English cases. I think I knew more about the English House of Lords than I did about the Supreme Court of Canada, just because those were the cases that we focused on. So, this was obviously pre-charter, the pre-emergence of Canadian law as a distinctive sort of branch of law, and with much less, as I say, theoretical emphasis. Ernie was was the new wave, and when he came on came on as a student almost, he was the story of the future of the law school, very much.
You were a classmate of Justice Abella's.
Rosie Abella was my classmate.
Yeah, and I'm thinking, did you, in your second year, third year, did you think, man, I would love to be a judge? I wonder if she was thinking that. I wonder how many judges graduated.
I can't speak for Rosie, but there could have been no thought further from my mind being a judge. I wasn't even sure that what I wanted to do. So what I decided to do was I decided that I would article, and I ended up at a little firm was then called MacKinnon McTaggart, which had produced some wonderful lawyers. Bert McKinnon, Ian Binney was there, Arthur Stone, Edgar Saxon. These people all were great lawyers, and they all became judges. So that's sort of when I started to maybe get the thought that I might do it. But I was sort of ambivalent about, did I want to practice? Did I want to pursue a more academic career? So what I did after I articled, actually, that's when I went to Oxford and did my DPhil degree, which was a wonderful experience, a wonderful 2 years. When I came back from that, I went back to the law firm, still very ambivalent about what I wanted to do. I probably have never really actually decided what I really want to do, I don't think. And it was sort of it was sort of like the way Ernie describes being hired. Mine was maybe not quite as unusual, but almost. Horace Creever, who was my civil procedure professor, and who I should have mentioned as one of the people who really strongly influenced me, had just been appointed as a judge. So the law school needed someone to teach civil procedure. So I thought, well, maybe I should explore that. So I called Marty Friedland, the dean, and I said, would you consider having me teach civil procedure? I wasn't thinking of a full-time appointment, and he really wasn't all that keen on it, and I was kind of disappointed. But then as we talked, and I told him about my the work I'd done as a graduate student. He sort of seemed to get more interested because my thesis was going to be published by Oxford University Press. So he was sort of impressed by that. And we talked, and it ended up that he then hired me. He said, just come for a year. Come for a year. You'll teach 3 courses. We talked about what courses I would teach. And then that'll give you an idea what it's really like. And so that sounded fine. And then at the very end, he said, oh, by the way, I've made it a tenure stream appointment. So that meant that if I liked it and they liked me, that would be a career. So it was today, this could not happen. This could not happen. I had no job talk. There I was, professor at the University of Toronto, which I could never have imagined what happened to me. And when I did the year, I loved being here. I loved the teaching. I loved scholarship and my colleagues, and I just stayed. So I stumbled into the job. That's the only way I can describe it. I stumbled into the job.
And Ernie, we know about you being brought into the dean's office and being offered a position teaching, but what are your memories of law school? Do they align with Bob's, or did you have a different experience?
Yes, they do align with Bob's, and I was a couple of years behind Bob. But what the law school in those days was, I've always thought this was a truly excellent law school. That is, if it was a question of teaching law, it was superb. And I came out of the 3-year experience knowing as I look back on it, knowing an enormous amount of law in every sort of area that was recognized as an area. Then it was just, there were some truly excellent teachers. And this is something I was very aware of because I was at the same time teaching in the classics department. So I had given some thought to what it is to teach at the post-secondary level. And there were some truly remarkable teachers. Bob mentioned some of them whom I knew and were teachers of mine. The people whom I remember most vividly as teachers were, first of all, Stephen Wadhams in first year, who taught me contracts. And I had known Stephen earlier because we had been undergraduates together in the classics department at the University of Toronto. So I knew him. I think I probably knew Stephen longer than anyone else who subsequently was on the faculty, since my acquaintance with him stretched back to our undergraduate days. So there was Stephen, who was, I thought, a spectacularly good contracts teacher. John Willis, who taught me criminal law, who was amazing as a sort of classroom personality. I was told subsequently by one of the old-time members of the faculty that Willis, despite his amazing intellectual self-confidence, got very, very nervous before he actually had to teach a class, that he would be seen pacing up and down the hall or pacing back and forth in the men's washroom, trying to get his thoughts organized to teach. But he was actually a spectacular teacher. He had a real presence in the classroom and an ability to immediately capture the attention of students. So one of the episodes that I remember from his class was the day he came into the class, started pacing up and down in front of the class, and began the class with these words, and this is a direct quote. They stuck in my memory. Ladies and gentlemen, today we are going to deal with the rise and fall of a magnificent fake defense, the defense of automatism. Now, whatever one might think of the substance of that comment, you could not it immediately grabbed your attention. I thought it was just an amazing way to introduce a class. And then he set out what he thought were the dimensions and the developments, and what he thought was the phoniness of this defense. But your attention couldn't wander from him. He was just transfixing in what he said and in the way he said it. So, and in later years, in the upper years, I remember as an amazing teacher, Frank Iacobucci, about whom I actually wrote as a teacher when he graduated. There's a volume of the University of Toronto Law Journal in honor of him, and I contributed an article called simply "The Teacher," where I talked about what it was like to be in his class and what the significance of his way of teaching was. Another figure was Albert Abel, who taught me constitutional law and administrative law. And he was the one truly Socratic teacher at the law school. That is, he really engaged with his students in a conversation. Usually he picked a student and engaged that student in conversation about the material of the day. And it was an amazing, I found that it was an amazing experience. I'm not sure all my classmates did, but I thought it was just terrific. And I always regretted when my time was as queen for a day was over, because I realized that he probably wouldn't come back to me again for the rest of the term, because there are other members of the class that he would want to question. Ted Alexander was a teacher of enormous clarity. He taught me torts and first got me interested in torts, for which I'm very, very grateful. And then there were other teachers who I thought were very, very skilled as teachers. Angela Swan taught me conflicts of laws, and I thought was a very, very creative teacher. Stan Schiff taught legal process and evidence. I took legal process from him, and everybody recognized that he was a very prickly fellow, but he was a wonderfully conscientious teacher, and his classes made a real impression. So the law school, I thought, was a very, very successful teaching institution, and I thought that I came out of the law school knowing a lot about law, and as Bob says, having been given lots of opportunities to think about law and invitations to think about law in the class, and so I found it a completely satisfying experience. And that's, in a sense, one of the motivations for continuing to the end. I didn't have too much to do with my fellow students in the class, because first of all, I was several years older than most of them, because I had done this graduate degree at Harvard and had been teaching classics. So I was a bit older than most of them. And for most of the time, for about half the time, I was married. As I said, got married at the end of the first term of my second year, and I was busy in the classics department. That is, I was shuffling back and forth from being a student to being a professor, and I was still a very active teacher in the classics department. So I didn't have a lot of time to engage in a lot of socialization with other members of the class, though I know some of them went on to become very distinguished lawyers. I actually have to tell you one incident. that I used to tell my torts class all the time. When I taught, there's a very puzzling case in causation called Cook and Lewis, involving two shooters who shot simultaneously, and someone was injured. The question was, what do you do about uh, the difficulty that the plaintiff can't prove which of the shooters actually fired the shot that injured him? And in this case, there was an absolutely amazing judgment by Justice Rand, which was spectacular. It was a very unusual judgment by any standard in its depth and its conceptualization. And I got very caught up in this judgment, so much so that before the class, I saw in the hall members of the study group that I belonged to. So there are 3 or 4 other people with whom I used to review the class materials. And I went up to them. They were standing in a group, and I went up to them and said, "Did you read Cook and Lewis? Did you read Rand's judgment in Cook and Lewis? What did you think of it?" It's a very enigmatic judgment, not clear what he's saying. I said, it's brilliant, but it's very, very, I don't understand it. What did you make of it? And they said, look, just simmer down. Don't get so excited about it. The prof will explain what the judgment is about. So just calm down. Anyway, so I would tell my class that those other people in the study group all went on to become very, very distinguished lawyers. And I would like to think millionaires in each fund. And I say to my class, but I'm still at the University of Toronto Law School trying to figure out Cook and Lewis. So it just occupied me for years and years and years. But as I say, it was a very successful learning experience. But I was also, and Bob in a sense alluded to this, I was also very aware when I joined the faculty that I did not want to reproduce that experience for my students. Um, um, it may be because I had already done graduate work in another discipline, or because I had never actually practiced law or even done any graduate work in law. So that I was very grateful for the very doctrinal and black letter knowledge that I acquired, but I didn't want to actually teach that. And I thought, well, whatever I teach, I'll teach. I'll try to teach the law conscientiously, of course, but I'll always try to say something additional about the law besides its black letter rules. And so that was my original resolution when I began to teach. But of course, the problem was that I didn't know what that something additional would be. I had no idea what it meant to say something, think of something additional. And it's only after a few years that of teaching that I realized that this was actually, that what I had stumbled into was a very complex philosophical problem about what it is important. What is it about the law that's important to say about it, aside from the fact that it exists in a certain rule-like form? And that then drove forward for me, the interest in legal theory, and that I would experiment in my class in tort law and try to teach torts in a certain way. But I thought that the education I had in law school was spectacularly good. As I say, Lorraine's experience, she was a year behind me, was much different. But it was also, as Bob said, the law school then was basically a white male club, and there weren't many women students. And I think it was also the case in those days that, and I would witness this sometimes in the classes that I was in at the law school, that the professors came from a world where um, women had a different role. And often professors could simply not deal with questions that the women students asked. Like, it wasn't that the question themselves were so outlandish, but the very idea of dealing with women students posed a problem to some of the members of the law school faculty then, but that certainly wasn't a problem that I ever experienced myself directly, though I was aware that Lorraine did.
I had a conversation with Lorraine recently where she talked about an interaction with a student who was a bit hostile towards her, thinking that she had taken a spot in law school that could have gone to his friend. And I appreciate that the experiences were different. I know overall, both of your experiences, especially with your professors, was good. You've been able to pick out the professors with the highest influence, and maybe it's my acting background, but I think of casting. What makes a good movie or television show sometimes just comes down to casting. And the faculty of law, at least now, they've done an extraordinary job with the legal scholars that are at the faculty of law. They're the best of the best, and listening to your affection for Iacobucci and Friedland, um, believe me, I hear the same things about you both from current students, and I hope that you'll both be at the law school for a very long time. It's great to see Marty in the hallway, and nice to have that connection. And the year 2024-25, we're celebrating the 75th anniversary of modern legal education. And as Lorraine would point out, the law school's come a long way. Bob, what do you hope for students for the next 75 years? What do you hope for the law school for the next 75 years?
Well, I would hope that the law school will continue on its trajectory. And, as Ernie and I have both said, it always has had a high aspiration. It did when I was a student, and it does now. It did when I was on the faculty. And I think it's very important that it maintain that. The aspiration, the sort of precise contours of the aspiration have, of course, changed as times change, and the way law is taught and written about has evolved. But I would certainly hope that the law school would maintain that high aspiration for excellence in teaching and excellence in scholarship, and an openness to a wide range of scholarship. So that's what I would hope that the law school would do. And I'm being back here is wonderful, and all the evidence is that it is continuing on an upward trajectory.
Excellent. And Ernie, how about yourself?
So I would second Bob's remarks. I I don't know what my aspirations for the law school over the next 75 years uh, would be, because I find that nowadays the world moves so quickly, and attitudes change so quickly, and technologies change, that it's actually difficult to forecast what the world will be like in 75 years or in 5 years. Like, it just seems like a different world. What I hope is that the law school continues uh, as it has over the last decades, and I think developing in whatever way is appropriate for what that future is that I actually don't know, and uh, feel um, uh, unable to anticipate. I think the key to it is that uh, in the final analysis, a law school is only as good as its teaching faculty. That's and that one has to appoint the faculty people who are who are actually the very best in every intellectual and legal sense. And if that um, and that one has to be aware that when one makes an appointment, it's not to solve an immediate problem, but to um, um, continue to create a faculty in which that person will serve for another 40 or 50 years. So these are really long-term appointments. And so um, um, the if I think the law school has a very bright future ahead of it uh, as it continues, and to the extent that it continues to appoint the very best people uh, possible, and then that faculty will make good collective judgments, one would expect.
Right. Thank you both. I did before we wrap it up, I did want to ask Justice Sharpe. You do have a book coming out, I believe, soon, and I'm hoping for an autographed copy. I don't mind paying for it, but I hope you do sign it for me. Can you tell us about your book, Bob?
Well, it's a book I never thought I would write, but it's a memoir, and it traces my life in the law, the sort of the three different aspects of what I've done. I've practicing lawyer, scholar, academic, and judge, and just how I have evolved and how the law has evolved during that almost 50-year, more than 50-year period. So as I say, it's a book I never thought I would write. When I left the bench, I had all this paper to deal with, files from my days at the law school, from my days on the court, and being something of a historian, I couldn't bear to throw them all out, which is what I should have done. But I started to go through them. I started to write, and I thought to myself, I don't care if no one reads this. This is just, for me, this is an interesting exercise to go through, to retrace what I did, and I sort of got captured by it. So you'll certainly get an autographed copy.
Excellent. Thank you. No, I'm very much looking forward to it. And besides the affection from the students and faculty here, I know an esteemed member of the judiciary. I do, believe it or not, have a friend or two who are judges, and the affection is real. And Ernie, do you have anything coming out that we can look forward to?
Yes, I have a book that's going to come out, I think, next year. That's going to be published by the University of Toronto Press. So it's something a bit different, though it also involves a summation of one's life, though not quite in the way that Bob's book does. So it's actually a book about a Spanish theologian in the 1500s, so it's a man by the name of Domingo de Soto, who is one of the great figures in Spain's golden age. And so this is basically a book about his theories of property and on the relationship between poverty and property, and what should be done, what is permissible, what means of regulation are permissible for the poor and for begging. And I say it goes it involves a different set of skills than the usual legal skills, because all the sources for the period are in Latin. So it takes me back to my career as a classicist, and reading these Latin sources. But the points that Domingo de Soto was making were all legal points. He was he was setting forth in this context elements of a philosophy of law. And so this is um, a book that's going to be published in a series by the University of Toronto Press called Toronto Studies in Medieval Law. So that's the immediate work that will be coming out. I suppose I suspect sometime next year, and I basically finished that, and I'm now turning to a couple of other projects that are even more distant, and I hope I can make some progress in those, as long as I'm capable of making any progress in anything. So that's the plan, and that's the this volume. And I must say, as uh, Bob also said, I don't know how many people will be interested in the legal issues concerning poverty in the early 16th century. I suspect the medievalists will, and the Renaissance scholars will. I hope legal scholars will as well. But I was just doing this because I thought it would be a fun project to do that would allow me to work with Latin text, which is what I wanted to do, but also to make use of my um, expertise in legal theory, which is very much in play in this book.
Well, I know both pieces of work will be important to future legal scholars, students the world over, and very much looking forward to that too. Hope to have an autographed copy from you.
Definitely, Justin.
And Bob, is your memoir also in a series? You have the Picton years as one book.
Yeah, well, yeah, the Picton years are there. The Western,
Okay,
the
it's just
Oxford
one book.
years. It's all there.
All in one.
All,
Where
boring though it may be, it's all there.
no, we're looking forward to it. Look, on behalf of the Faculty of Law, I wanted to thank you both for joining us today. We've taken up a lot of your time, but it's been great speaking with you both to learn a bit of your past and what brought you to law school and what your experiences were like when you were students, and what you're looking forward to for the law school of the next 75 years. Again, I'm Justin Landry for the Faculty of Law. Thank you both for joining us today, and look forward to reading those books.
Thank you.
Thanks a lot, Justin.
Have a great day.